Hi, everyone. What I want to speak about today is the role of law. Of course, Suleiman, the famous Sultan Suleiman, is known as the Magnificent in English, but he's known as Kanuni, the lawgiver, in Turkish. And what is it about law that made him special? But to understand that, we have to go into the basics of some pieces of Islamic law, of state law, and how that all worked out in the Ottoman Empire. So let's jump into this. To begin with, we have to think about something called Sharia. Sharia is something you might have heard of. Certainly, it occupies a great deal of intellectual space in the realm of right-wing Islamophobes. There's a worry about Sharia creeping into our schools, into our legal systems. This is all, of course, false. Sharia can't do that. All we have is our own laws. But we still don't have a good sense of what exactly is Sharia. And so we can start off with just the idea that what is Sharia in general? It literally just means way or path, but often it's translated as Islamic law. Now, the question is, what makes it Islamic? What is it about this law that makes it Islamic versus, let's say, the law, the statutes of the state of California, or some other form of law? Are there non-Islamic systems of law in the Middle East? And then what I hope to get at is how does it function as a system of law? How is it different from our current system? And ultimately, and perhaps more relevant to this class, how did the Ottoman state transform Islamic law, or at least the Sharia? To get at this, we have to get at the very basics of what Islamic law. One thing to think about is ask yourself, is Islamic law codified? Is there like a book of rulings that you could go to and see, what happens if I murder someone, or if I'm cheated by a company or by a financial partner? What happens if I commit adultery? Can I be punished for that? Is there a law book in which those ideas or sentences or rules are written down? Essentially, no, there is not. Islamic law is in a sense flexible in that it has the sources, it has legal rulings about how to approach that, but it does not have one codified set of laws. Eventually, those were codified into state laws in the 19th century, but we're not going to get into that right now. Instead, it has something called the Sharia, and this was the law created by the jurists. We'll talk about who the jurists were, but basically they're just Muslim scholars thinking about, well, what is the example of the Prophet Muhammad, and how can we derive larger ideas and rulings from that? The other side of law is what's called Kanun, or in the cognate in English, canon, like canon law. This is essentially law set out by the Sultan and the ruler, or the ruler, right? So as we'll see, this is law that goes into places where Sharia can't. Sharia covers a lot of things, as we'll see. It covers not only obligations between people, so example, if you murder someone or cheat someone or do something like that, but also obligations between a person and God. So the way you're supposed to pray, the way you're supposed to fast, whether or not tobacco is permissible. All these things can technically be covered by Sharia, whereas Kanun focuses on, for example, the way the government is structured, whether you have a set of ministers or not, and how you would move through a set of jobs, etc. Also, there's certain things that are very difficult to prove in Sharia. For example, murder, banditry. You would have to find a whole bunch of 4 witnesses and to bring that person to court and then find them, etc. All of this is quite impractical in the realm of Sharia if you're just trying to stop bandits. So in that case, Kanun steps in and basically is the sort of will, the legal will of the Sultan, says, I'm going to punish these people using executive authority. Finally, there's something called urf. Urf just means like the way things are done. Customary law is another way of thinking of it. What does that actually mean? Well, we have all sorts of situations in which we have customary law. So, for example, maybe you and your friends run a business and you just kind of come up with some basic guidelines for your business or for your group. These aren't set down by any state. They're just the way things are done, which you've kind of informally agreed upon. So often guilds or things like that would have ways of doing that. A village might have a way of splitting up agricultural land. But also, for example, a university has guidelines, a code of conduct in which, cheating is seen as incorrect or wrong, and you can be punished for it within the university. But that guideline doesn't hold any water legally in the state of California. The state of California is not going to prosecute you for cheating on a test, nor is the federal government going to come in unless it violates some sort of rule of the federal government, for example, anti-discrimination laws. So what we have here is three sets of laws. Today, in our society, we just have basically kanun, derived not by the president, but the legislative branch. And we do have things like urf, customary law, but this is, again, informal and unrelated necessarily to the law of the legislature. So in Islamic law, there are two basic jobs, two roles. First is the qadi. The qadi is essentially a judge. He can also, in the Ottoman period, be a sort of magistrate. He was also appointed by the central government. He was helping run a province alongside making legal judgments. But they take the specifics of a case. They take two people, one person accuses another of murder or of cheating or of something like that, and they look at the law and they make a judgment on that specific case. Now, the mufti thinks about, or the jurist thinks about law more broadly. It doesn't look at this specific case. Instead, they abstract a legal problem. For example, as we'll see, what to do in a new situation, like, is it permissible? Like, there's a new substance called tobacco. Can that substance, is that legal to ingest or not? And how should it be controlled, etc. These are problems that a jurist would try to solve. If there's an unclear legal situation, you would go to a jurist, a mufti first, to get a fatwa or a legal opinion to try to bolster your case, and then you would go to the judge and then try to have that legal opinion applied. So in our legal system, those two roles are basically combined. The judge looks at the law, makes judgment, but is also creating new legal opinions, creating new legal precedent. The jurist, the people creating the actual laws, on the other hand, to some are separate. They're the legislator. So the other thing is that the jurists are technically independent of the state. So the state does not have any direct say in what the jurists do or decide. And in fact, no one is appointed a jurist. Their authority comes from their piety, from their learning, and from the respect shown by other people in the society. It's a somewhat informal system in that sense. Whereas, for example, legislators are elected and are state representatives today, or on occasion in other autocratic governments, are appointed. This, though, doesn't apply to judges. Judges in the Islamic system were appointed by the ruler. And in this sense, we had a trade-off, right? The ruler appoints the judges operate independently, as do the jurists, but the ruler is still kind of the one paying for the judges to operate. As we'll see, this relationship changes during the Ottoman period. So let's just very quickly look at what a court ruling would be like. And this is what judges were doing in the Ottoman Empire. On the left, you see here a court register. This is the register where they would basically write a summary of every court case that was brought to them, including the witnesses who were there, listed at the bottom, and the signatures. There aren't signatures, but list names of witnesses, and a summary written by a scribe of the relevant legal facts. So, for example, if you were to look at different cases, you would find maybe, for example, this one, the caravanserai raided, Fatima apprehended drunk. The occasion for the drafting the record is following. The janissary, so the soldier, Bekir ibn Abdullah, Bekir, the son of Abdullah, from among the patrolmen of the Mamure neighborhood, appeared at the court of law and stated, I was informed that some toughs bring prostitutes to the caravanserai of Arpajeh Hussein. I went there together with the undersigned Muslims, but the fellows fled. One left his raincoat, his jacket, his vest, his belt, 2 old felt caps, an old shirt, his muslin, 2 Shahi coins were also found in his clothes. After much tumult and searching, we found this Fatma bint, the daughter of Mehmed, with them and brought her here. She is still drunk, her mouth smells of wine. When the aforementioned woman was asked, she was unable to deny it. On request, it was recorded that she was drunk and her mouth smelled of wine. It has been recorded that the woman was given over to the chief of police, Ahmed. And then you have written in the date of 1583, witnesses being 4 free men, Muslim men. What you have here is a bit different. You have people bringing forward a woman to the judge to record that she was drunk and that she was given over to the chief of police, Ahmed. Here, there is no punishment. It's just a recording of an event, right? And this is one of the things we'll see, that the government, there's no prosecutor role. The government is not going out and stopping people. In fact, the court system relies on people bringing cases against other people, kind of like civil court in our society today. So there's no real criminal court. Now, in this case, there's a man, Bakir bin Abdullah, along with some patrolmen. They are trying to establish order in their neighborhood, and they raid as in their role of patrolmen, raid someone, and then bring them in front of the judge for punishment, right? They're not applying the punishment. They're not doing anything. They're bringing her forward for the sake of, it's not their role to develop or to punish this woman. And even here, the judge is just recording that she has been turned over and then given over to the chief of police. Presumably, there would be another, perhaps a punishment, perhaps not, perhaps she would be released, perhaps there was, but we have here is different evidence, basically witnesses reporting that she was drunk. Public drunkenness is to some degree and not an acceptable, is against the law. Other times we have all sorts of different events just recorded in these court records, which end up being quite interesting, especially events ordered by the imperial government. So as the conquest and subjugation of Uyvar, which is a place in Slovakia, in Nové Zámky, was facilitated by God, a noble order and a felicitous imperial decree was issued to hold illuminations in the city for 7 days and 7 nights. So the Ottoman Empire conquered an area and there was state celebrations. It's necessary for the doors of the shops and houses and the markets and bazaars in the city of Constantinople to be illuminated for 7 days, 7 nights. In accordance with imperial decree and noble order, people should occupy themselves with praying for the continuation of life and fortune of the Padishah. Padishah is another name for Sultan. Now, what we have here is just an imperial order basically saying, you guys have to go do this. And this order comes from the Kanun, the imperial government, and it's kind of recorded in these court records. So in these court records, we have all sorts of different pieces. We also have just other events that don't quite fit into, they don't get resolved. So for example, here we have Ali bin Abdullah, son of Abdullah, and Mehmed, son of Ilyas, in the village of Kade, appeared at the court of law. Ali brought the claim and said, one of my horses walked loose at night and entered your vineyard, and you cut off the tail as punishment. Mehmed was questioned. He denied the allegation. When proof was demanded of Ali, he was incapable of producing any. Mehmed was asked to swear by God 3 times, from which he abstained. It was recorded in the register. So basically, this is a case one neighbor brought the case against the other. No witnesses, no clear evidence. When in this case, what they do is they ask people to take an oath, swear by God 3 times, but Mehmed refused. This would suggest that he is guilty, that he refused to defend himself and say that before God, he didn't do this thing. I've always wondered why it is that people were so willing to, or unwilling to just swear an oath and get out of things, but that is what it is. In this case, we don't have a punishment listed or anything, but we do have a case, a weird case in front of the court. Other times we have, these are examples of fatwas, things that jurists would deal with. most of them are about very minute legal matters and minor details and variations on different cases. But sometimes you get all sorts of bizarre things about daily life. For example, in one side in a village, Christians claim that Jesus, utmost peace and prayers upon him, was born. They built upon this site a church and erected his statues and paintings, but Jesus' birth in that site is not confirmed by an authoritative and correct source. Is it acceptable for a Muslim to enter this church for the purposes of pilgrimage or not? This is not about between two people, right? This is about relationship between a Muslim and God. Can they enter this church and go to perform pilgrimage, like small pilgrimage at this church, or not? Is the fact that it's not confirmed changing the nature of this pilgrimage? Is this acceptable for a Muslim to enter a place, especially if there's paintings and statues? What can we do here? In this case, it's not quite clear. I don't remember exactly what the final ruling was. I think it was that was okay. But what you can see here is that this specific incident has kind of been stripped of direct details. We don't know which village, we don't know which Christians, we don't know what exactly is the proof that the villagers are providing or not. But there's a general question: is it acceptable to enter a church where Jesus was supposed to have been born, or not? And if so, what is it harming a Muslim? Other times we have this weird one, which is it permissible to take a glass bowl or a glass cup of wine and place it in a bright location and look at it with pleasure? Response is permissible, but not encouraged. So in this case, wine drinking is not allowed. But can you appreciate wine in other ways? For example, visually, would that visual effect have some sort of transformation on you in a way that would be negative? In this case, it says it's permissible, so it doesn't make you drunk, but you are kind of like encouraging wine drinking, so probably you shouldn't do it. Another real life problem, which we discussed in our discussion section, is it permissible to drink coffee, right? So the Quran and the Hadith say nothing about coffee itself, because this is a substance that came hundreds of years after it was discovered around the 1400. So how do they come up with a decision about these situations? Again, coffee is originally from about somewhere from Yemen or Ethiopia. Started being drank in the 15th century for different Sufi rituals, but then it migrated into being used in general amongst the urban populations, first in Medina, then Cairo, and then in 1550, the first Istanbul coffee house appeared. Here on the left, we see the only depiction of a coffee house we have in these miniatures from the time. We can see actually it's a bustling place. People are trying to get in. Doesn't seem like there's enough space. These guys are on a raised platform drinking coffee. This guy's preparing the coffee. A lot of people have books in their hands. They're writing, they're exchanging poetry. I think this is a fan. They're playing games. This is a dancer. And there's even music being played here. There's even an old man who's being helped to drink coffee. So they're places of conviviality. And it's that mixed nature, the sort of unclear social space that coffee houses provided, that made them disreputable to some degree, but also very attractive. But coffee houses eventually became integrated so much that coffee house workers became their own guild, and there was a big parade of guilds where they all created models of their different work, and they marched through the hippodrome, as you can see here. This is a closer vision look at this miniature. You can see just how everyone has some sort of head covering, usually with a feather or something stuck inside for decoration. Not sure who this guy is with this other type of head covering. Maybe he's a boy, because you could see he doesn't have facial hair. This is a dancer, or it should be a coffee server, a beautiful boy. And if we look down here, we can see different people, musicians. Again, people with their books out, playing with fans, trying to cool themselves down. This guy's taking his turban off. They're playing backgammon. I can't remember what this game is called. And we see an overall interesting situation. Over time, coffee houses became much more respectable. This is an 18th century engraving of a coffee house, which you can see here from with an overview of the Bosphorus. So it was meant to kind of take in. You can also see here, if you look closely, people are smoking tobacco, either through a shisha, a glass pipe, water pipe, or through, more commonly, through these long poles that would, the bowl would be at the bottom here. And here you can see the guy preparing the tobacco. Interestingly, coffee, by the way, was brought over from the Ottoman Empire to the European realms. So the first coffee houses in Europe were opened by Ottoman subjects, Ottoman Christian subjects, Armenians, Greeks. I think Armenians started the first one in Vienna. Greek subject, Ottoman subject started one in London around 1650, so about 100 years after it became widespread in Constantinople. And it quickly took off and carried much of the same usage in European society at the time as a place to discuss politics, to read, to engage with. And just like the Ottoman Empire, it offered a different place than the tavern or the pub, right? In the Ottoman Empire, you could also come and hang out in a tavern and probably do many similar things. But this was a bit more respectable. You weren't drinking alcohol, and you were still engaging socially with many other people. So is it permissible to drink coffee or not? There's a variety of different things here. What a jurist would do is basically start with the Quran. The Quran says that you cannot drink, you should avoid wine, gambling, and idols, that they're a means of defilement of Satan's doing. Avoid it so you may happily prosper. But wine just means khamar, which means wine made from grapes. So that suggests that alcohol made from not grapes should be okay. But then we look at the hadith, the sayings of the Prophet Muhammad. He says, every intoxicant is khamar. Every intoxicant is forbidden. So actually everything that makes you intoxicated is forbidden. Now you need to figure out, well, what does it mean to be intoxicated? So here you would look at the authoritative opinions of early jurists who would sit around and define, well, what does it mean to be drunk or intoxicated? And we see again that absent-minded, confused, one whose mind leaves him and knows nothing at all, foolish, ignorant. The drunk is one who comprehends absolutely nothing, can't tell the difference between a man and a woman, from the earth to the heavens, so you lose the rational capacity of the mind. And then you have to decide, well, is the coffee creating that state of intoxication? Now, the medical opinion ultimately is not as important here, but it can give you some information. And it's mixed, basically. Some people don't say anything about coffee, at least the intoxicating effects of coffee, but talk about its medical purposes. Other people say that it destroys the body, the hearts and guts are weakened, the drinker suffers delusions, and the body receives such a shock that it is as though it were bewitched. So here we have a situation in which one anonymous author says that it's not allowed, or that has a negative effect. And in fact, early on, people found that coffee to be generally not legal to drink. That didn't stop people from drinking it. And in fact, most of the government's effects on trying to stop coffee drinking were not aimed at coffee itself, which was often drank privately, but at coffee houses, which they saw as spaces of disorder and bad morality. So jurists would then go through and basically decide whether or not things were obligatory. So certain things you have to do all the time, no matter what, like praying. Things that are recommended but not obligatory, for example, learning the hadith. Things that are neutral, that don't have one way or another. Things that are discouraged, like coffee drinking, but are not forbidden, or smoking tobacco. And things that are completely forbidden, like murdering people or drinking wine. So the question with tobacco and coffee drinking is it discouraged but okay, or is it prohibited completely? So what this shows is that in Islamic law, you basically have a variety of different sources. The main one is the Quran. The Quran doesn't really tell us that much, though. The Quran basically gives us an overview of of kind of spiritual commands that Muhammad received as direct messages from God, but it doesn't tell you how to act. It's, it's often focused on moments of the end of times or how to pray, telling people to believe in God. And so the other space that you would have to go to is not the Quran, but the Sunnah, which is a kind of tradition. These are basically actions and words of the Prophet Muhammad, which are called hadith or akhbar, reports about it. These create a sort of authoritative precedents that help us interpret the Quran. Basically, it covers anything that the Prophet Muhammad did. Did the Prophet Muhammad like to wear silk? No. People ask him constantly questions. What should I do with my child about this? How should I be a good Muslim? What should I do in this situation when someone's cheating me? All these different things give information, which then help us create prophetic precedents, which then allows the creation of something called law, where you can try to figure out, well, how should you act and what should the rules be based off of these sources. Now, of course, in our vision of law, we have something called natural law rather than religious law, which is kind of invented in the 18th century, the idea that there's kind of natural rules that govern humans that we can figure out and that we can decide and enshrine in constitutions or in legislators or things like that, that you don't have to necessarily rely on church law, etc. So, for example, today we don't use religious sources like the Quran or the Bible or other spaces to create law for people. But in the end, Islamic law, just like any other system of law, creates rules for people to follow in situations and to figure out how to proceed legally in different ways. So it's not that different from what we have today, except ultimately it's based off of what the Quran and what the Prophet Muhammad said. Now, there's two things here. What is the ruler's actions and rulings? Where do they fit into? And what happens when an issue is not addressed by these sources? Well, then you have to kind of figure out two things. One is the role of the ruler is technically minor. He's not supposed to, at least after the year kind of 800, 850, not supposed to be able to affect Islamic law directly. All he can do is appoint the judge, but he's not supposed to intervene directly in this situation. The question as to what happens when you encounter something that is not dealt with in the Hadith or the Quran, then you have to use different legal methods, like we did, to look at the question of something like coffee or tobacco. The most common one is something like called qiyas or analogy. But otherwise, you would look at something like ijma, consensus. So if all major scholars kind of agree on a situation, and that's probably the best version, then there's ijtihad or kind of independent reasoning. This stopped being used as much after the first few centuries, but where kind of major scholars just decided to reason through something without necessarily relying on a prophetic example. Most of the time, instead, they relied on something called taqlid, adhering to authoritative precedents of what former judges used to say. But you can always change the law and make it more flexible by talking about istislah, kind of thinking about the public good. So in a certain situation, it might be public good to follow something that technically is against the law. Or in dire circumstances, you can overrule laws and develop things. So Islamic law is relatively flexible and it constantly changes. So it banned coffee, but then it kind of allowed coffee, or at least jurists allowed coffee. The same with tobacco. Both the state and the Ottoman state and the jurists kind of banned tobacco for 50 years. But then it was eventually just allowed because everyone was using it. So it wasn't seen as, it was in the favor of public good to allow people to do it. Now, based off, this is just information, but based off of which legal mechanisms you prefer and which forms of precedent you like, there's different schools of law each of them have different principles and kind of theoretical approaches to the idea of law. And specifically, they argue over the role of individual reasoning. There used to be a lot of these, but by the time of the Ottomans, there's essentially four. There's the Hanafis, the Malikis, the Hanbalis, and the Shafis. For our purposes, the Ottomans were Hanafis. This was very heavily present in Central Asia. The Ottomans took a lot from Central Asia. That's why they ended up being Hanafis. The Arab Middle East was usually Shafi. Malikis like North Africa, Morocco, and Hanbalis. There's no real Hanbalis, but there's small pockets in Baghdad and Cairo. Usually there's multiple courts based off of each law school. At least that was the case in the Ottoman Empire. There's a Hanafi court and sometimes a Shafi'i one. And so you could kind of venue shop between the two. Women often if you want to get divorced, went to a Hanafi court because it provided more favorable rulings to them, gave them more rights, etc. And people knew the differences between the two, and so they could kind of move around as they wished. Now, what did the Ottomans actually do in the nature of Sharia? They did a few different things here that actually changed Islamic law pretty drastically, though it seems in some ways minor. They didn't undo it or anything, but they put the state in the middle of it in a way that hadn't been done before. One is that they created courts in every town and city starting around the mid-16th century. So there were already, of course, Islamic courts, but they were kind of informal, right? They were in the city, they were supported by the local ruler, but didn't necessarily keep their records. They weren't mandated by the state. Like you could go and find an Islamic judge, but you'd have to probably go to the major city, etc. Or you'd have to find someone willing to do it. Here, under the Ottomans, we have something different. They basically forced every major city and town, every kind of medium and large city and town to have a judge and to run a court with scribes and deputy judges, etc. If in big cities, you'd have multiple judges. So a place like Constantinople, you'd have 30 or 40 courts. Or same with Cairo. The court records actually still survive to this day, and they're an invaluable source of local information about what's happening in these cities, because we don't really have local archives, but we do have these court records, which, as you saw, tell us all sorts of information. And courts are open to everyone. They're ultimately used by Muslims and non-Muslims, freed people and slaves. Anyone who wants recourse to imperial justice can use them. And this was part of the appeal, kind of one of the reasons why Suleiman was known as Kanuni, the lawgiver. And in fact, over time, they really became a space of public record. So everyone used them to record property sales, to do endowments, to do inheritances, register to some degree marriages and marriage contracts. All this stuff started getting recorded in the courts. Of course, you could always not use the courts, and you could still resort. If you got married and you didn't formally register your marriage contract, you could still come back and say, I have witnesses saying I gave this as a dowry and I want it back now that I'm getting divorced or something like that. But Ottoman society became much more legalistic, became much more obsessed with documentary evidence, partially because of the creation of these courts. If you didn't like what and the ruling you had in the court, you could appeal it. You could go to the palace in Constantinople, Topkapi Palace, go to the Divan, the Imperial Council, and basically appeal the court. And they would function as a sort of court of appeals, or they might throw it back down to the lower one. So here's an example from the court registers of Aintab, the very first ones we have. The married peasant, these are summaries, right? The married peasant woman, Can Pasha, accuses one Hamza of entering her house at night, climbing into her bed and assaulting her. So a rape case. Hamza denies this, whereupon investigation among the people of the village shows that he has been similarly accused with regard to another woman in the village and therefore has to admit. Hamza is sentenced to punishment by the judge. So in this case, there's an accusation, and then there's an investigation, and the evidence is not witnesses, because there weren't any witnesses, but there is circumstantial evidence that similar accusations and he had about this man, and that he had a certain reputation for doing this. And this ultimately results in him being punished. Now, I don't think it says what the punishment is, but you could figure that out. Mezid brings a case against Husniya, wife of Sheikhi, saying that when he was staying at their house, Husniya came to him in bed after Sheikhi had fallen asleep. Husniya's character was investigated. 3 men of the neighborhood testified that we have never known any ill conduct in part, and we cannot say she is prone to bad behavior. So in this case, a woman is accused of sexual aggression, but there's no evidence. We have 3 character witnesses, again, all independent, adult, male, free Muslims, which is the best type of witness. On occasion, you could take things to the appeal courts. It was easier if you lived in Constantinople. Here, this is a case from the appeal court. In 1775, the sellers of new shoes took the sellers of old shoes to the imperial court, accusing them of buying new shoes from the cobblers and selling them among their wares, contrary to the established custom. So here we have something violating customary law. In this case, the guilds split up businesses according to very specific limits, right? So people who make new shoes, cobblers, cannot sell used shoes. Any people who sell used shoes cannot sell new shoes. Everyone has their place, and this is the way of maintaining a proper business environment. So it's the opposite idea of disruption, right? The idea of like a tech disruptor is to kind of break into a set economy and to make money off of that disruption. This is absolutely not allowed in the Ottoman case, in Ottoman economic thinking. The new shoe sellers also claimed that the practice of the old shoe sellers caused a shortage of shoes and an increase in prices, right? Because all of this was mandated. They mandated the price of raw materials, and everyone was given a set amount of raw materials to maintain economic livelihood. So this was breaking this up. In defending themselves, the old shoe sellers indicated the fact that new shoe sellers intruded into their line of business by selling old shoes among the new ones. The Divan referred this case to the Qadi of the District Court of Istanbul. The Qadi made the parties agree that henceforth they would never intrude into each other's business. So this was thrown back down to the lower court, who basically made them agree. By the way, in these cases, the ideal subject is a free Muslim male. In our current society, all people are technically equal before the law. Of course, this wasn't the same back in 1780 or 1795, where a person who was white, who was free, who owned property, had more rights and more say than anyone and than other people. So like many pre-modern or early modern situations, this is not an egalitarian society. That doesn't mean that women or non-Muslims or slaves didn't use the court system, but they knew the rules. So they knew that they had to get free male witnesses. And in fact, a woman's testimony, a slave's testimony, a child's testimony or a non-Muslim's testimony is worth half of their equivalent, right? So a free male Muslim testimony is worth more than that of any of these people. And so you needed to get the proper witnesses on your side. And there's different standards of witnesses, how many witnesses you need for each case. So even that said, what's interesting is that sometimes the court records would systematically misspell non-Muslims' name, at least to differentiate them as non-Muslims. So for example, the name Yusuf, which is a name used by both Christians and Jews and Muslims, it's spelled like this in Arabic, but they changed one letter, which wouldn't change the pronunciation, but would change the spelling to kind of when the person was a Christian. So in these cases, when it wasn't clear who was Christian or Jewish or Muslim, they would kind of mark that out in the court records. So it suggests that even when people were seeking out imperial justice, the courts were still differentiating between these subjects. Ultimately, people didn't take things to court unless they really thought they would win. Most people knew what the judges would rule, etc. This led people to settle out of court to avoid court cases unless they really didn't know what the ruling would be. I'm going to very quickly go over what other transformations the Ottomans did, which is also transformed the very structure of law. So, and this is major. Technically, the Ottomans, or say technically in Islamic societies, the judges were appointed by the ruler, but the jurists were independent. The jurists were taken seriously by their public reputation, how pious they were, how learned they were, the reputation of their families, etc. And your reputation could spread over relatively large areas. Now, what the Ottomans did is that they appointed a hierarchy of jurists. They appointed the jurists, they created state jurists, and this was really different from before. So not only did they appoint judges, but they also appointed jurists. Now, there were also independent jurists, etc., who continued to function, but there was now official state jurists whose opinions were more important and whose opinions carried more weight in the situations. Now, what this meant is that people who were outside of this system, for example, many scholars in the Arab world, who were technically often more learned than their counterparts in the Ottoman Empire, at least in the 16th century, all of a sudden were kind of marginalized. Moreover, the Ottomans had adopted Hanafism as the official state law school of the empire. And so they, whereas the Arab scholars were technically Shafi, and this made an entirely different set of spaces and roles that prioritize different legal judgments, etc. But really, the most important thing here is that the jurists were now appointed by the state. And they even created an entire hierarchy, a learned hierarchy, where you start off as a student in a madrasa, you got a sort of degree, and then you could either just become a judge in a small town, or you could become a professor. You could keep going up the ranks of different universities to get to the top, or at any of this time, you could also jump into the kind of magistrate level and become a sort of imperial judge, basically sent out to cities to work as a sort of judge and governor. There was also a governor, but the judge played a part in imperial administration, until eventually you could become the Mufti of Istanbul, which is also known as the Sheikhul Islam, the chief jurist. This was the very top of the pyramid. There was only one at a time. His rulings were the most authoritative, and they were eventually collected in big books, which formed kind of the legal books of fatwa, which created new law in the Ottoman Empire. The most famous one under Suleiman was a man named Ibn Saud. He was famous because he reconciled the decisions that the Ottoman government had made just on a whim or for practicality with the Sharia. He reconciled the Sharia and the Qanun. So the Qanun were the decisions the Ottoman government made at the whim of the Sultan, and he basically gave it some Islamic backing. So this re-transformed the nature of Islamic law and of Qanun to make it seem much more just and legitimate. And with that, we're going to end. Bye.